Would you like to finally get your will and your estate plan in order, but don't know where to start? If so, then this informational video is for you. Today, I want to share with you a checklist that will help you organize your thoughts so that you can decide which estate plan is right for you. You may ask, just what is an estate plan? An estate plan is simply your instructions on what you want to have done should you become incapacitated, or what you want done after your death. Wouldn't it be nice if someone handed you a checklist, knocked on the door, and let you know everything that you need to know about your estate planning? I get it. We both know that estate planning can seem overwhelming and something that you would just rather put off. Well, don't. Estate planning does not have to be complicated at all. You may ask, how do I know where to start? How will I know if I've made the right decision? Well, follow through with me on the checklist that I share, and you will be well on your way to accomplishing your goal of getting your estate plan done. And that's great news. The more informed you are, the better choices you will be able to make. So you ready? The checklist that I'll share with you today will cover important documents that you can consider if you want to have your estate plan in order. So let's discuss them. They are: number one, a financial power of attorney. In your financial power of attorney, you can appoint an agent to handle all of your business and financial affairs. Number two, complementing that is the medical power of attorney. Here, you can appoint someone to make all of your medical decisions if you cannot do so for yourself. Third on the checklist is a directive to physicians. This is also known as a living will, but is not a will at all. A directive to physicians allows you to state for yourself in advance whether you do or do not want life support. Another very important document to consider, and number 4 on the checklist, is a HIPAA form. Why is this important? I'll explain more in a bit. Have you ever considered who you would want to take care of you or your minor children should you become incapacitated? If so, then a designation of guardian is important and should be number 5 on your checklist. Let's round off the checklist with a will and a trust. I'll discuss in more detail so that you can decide which is the best for you. In addition to going through this checklist, at the end of today's informational video, I will provide you with a link where you can obtain a consultation, free of charge, covering questions that are important to you. Hi, I'm Jim Soto with the Soto Law Firm, a probate, guardianship, and estate planning law firm located in Houston and serving clients throughout Texas. You don't have to go through the legal process alone. My 25 years of experience will serve as your guide when you need it the most. The checklist that I share with you today will help you understand documents that you may want to include in your estate plan. So you ready? Let's go. Number 1 on the checklist is a durable power of attorney. This is a document that allows you to name an agent to act on your behalf to handle all of your business and financial matters. It does not have to be witnessed, but it does have to be notarized. You can revoke it at any time, and you can decide whether it takes place immediately or upon your incapacity. Tip: a durable power of attorney can go a long way to helping you avoid a costly and time-consuming guardianship. Okay, let's move to item number 2 on the checklist of documents to consider in an estate plan: medical power of attorney. A medical power of attorney allows you to appoint someone that you trust to make your medical decisions if you cannot do so for yourself. Here's another tip. If you are anticipating surgery, or if you have an underlying health condition, a medical power of attorney may be very helpful for you. And just like with a financial power of attorney, a medical power of attorney can go a long way in helping you avoid a costly guardianship. A third document to consider on your checklist is a directive to physicians, also known as a living will or an advance directive. It is called an advanced directive because it allows you to let others know in advance what medical treatments you would like, as well as those that you don't want. Most importantly, in a directive to physicians, you can state whether you do or you do not want life support. Fourth item on the checklist is a HIPAA authorization form. Just what is this? A HIPAA form is a document that allows you to appoint someone else to have access to your medical records. The reason that this is important is because the HIPAA form works alongside with your medical power of attorney. It gives the person of your choice access to your medical records so that they can use that with your medical power of attorney to make an informed medical decision on your behalf. Fifth item to consider, designation of guardian. This is a super important document because it allows you to nominate the person of your choice to serve as a guardian of your minor children if something happens to you. Of equal importance in a designation of guardian form, you can state who you do not want to serve as a guardian of your minor children. The documents that we have discussed up to this point are important because they can help you while you are still living. After you pass away, your will or your trust then comes into play. Let's discuss these now. Most people are familiar with wills, but perhaps not with the requirements of a will. A valid will in Texas must be witnessed and notarized. And your will can be amended or revoked at any time during your lifetime. Why is it important to have a will or a trust? Because if you do not have a will or a trust, then after your death, your property will be distributed according to the laws of intestacy. That is, through the laws of intestacy, the legislature has decided on how your property will be distributed if you do not have a will. This depends on if you are single or married, whether there are any children outside of the current marriage, and whether your property is community property or separate property. Yes, it is complicated. And that distribution may not be what you wanted. You can avoid all of that confusion with a will or a trust. Now, if you want to wrap up all these documents that we have discussed and place those into a nice, clean package and avoid probate, then you may want to consider a revocable living trust. In doing so, you may be well on your way to having your estate plan in order and avoiding probate. So, moral of the story? Take the time to organize your thoughts and then use this checklist to help you decide what you want and what you don't want. Once you have written down your thoughts, then you are well on your way to getting your estate plan done. So there you have it, documents that you can consider in setting up your estate plan. Let's recap. First, we talked about the financial power of attorney. Then we discussed a medical power of attorney. We also talked about a directive to physicians so that you can make your decisions known about life support. Our fourth item on the checklist is a HIPAA release, and we discussed how that complements your medical power of attorney. Fifth, we also discussed the importance of a designation of guardian as part of your estate planning checklist. And then, as item number 6, we talked about wills and trust. To get you started, I have set aside a free legal consultation to answer any questions that you may have about estate planning. So make sure that you go over to my website and schedule your consultation. I will include a link at the end of this video as well. Remember, you don't have to go through the legal process alone. Step by step, I will serve as your guide. Call me. I look forward to meeting you.